Hello, everyone. Today we're discussing the bodily injury investigation and claim conclusion. This investigation is essential to the claims handling process and provides vital information eventually needed to conclude the claim. An adjuster will create a plan to investigate whether a bodily injury, as alleged by the harmed party or the medical records, is consistent with the information that the adjuster found in their general investigation. In simpler terms, the adjuster is looking to see that the injuries claimed are or could have been caused by the accident or incident, thus proving or disproving causation. Planning your investigation well allows you to continue to identify and gather information and documentation, analyze the documentation you've gathered, assess the treatment, disability, and impairment of the harmed party, and monitor and update the plan as appropriate. In the case of a bodily injury claim, the direction and focus of both the bodily injury investigation and the general investigation is determined by the kind of injury the harmed party is alleging, along with the facts of the case. Reviewing various medical documents belonging to the harmed party allows the adjuster to plan the initial direction of the investigation based upon general questions asked about the claim. The process is then further developed as various healthcare providers are identified, the need for additional appropriate documentation is recognized, and periodic follow-up communication can be scheduled. It should be clear by now that the medical records are really the building blocks of a bodily injury claim file. It is very imperative that adjusters understand what information is contained in different medical records and reports and which records should be obtained. Being an essential part of the bodily injury investigation, medical records should be requested and gathered according to current legislation and within the privacy rights of the harmed party, as they will serve not only as providers of information, but also as claims evidence. The process of building bodily injury claim file really revolves around the evidence or medical documents that the adjuster gathers. Being the valuable sources of information that they are, medical documents need to be well organized and analyzed so that the treatment, impairment, and disability involved with the harmed party can be properly assessed. As the aforementioned process is occurring, the adjuster must also work to investigate and answer two primary questions. Did the accident cause the injuries or conditions from which the harmed party suffers? And was the treatment the harmed party received necessary? Sometimes experts are needed to answer these questions, so an adjuster may enlist the assistance of peer reviewers to review the medical documents and provide an opinion, or the adjuster may even need to request that the harmed party submit to an independent medical examination, an IME, so that a disinterested third-party physician can review the case, examine the patient, and provide. Ultimately, a thorough bodily injury claim investigation involves the adjuster following the four best practice steps to include identifying and gathering injury information and documents, analyzing records and reports, assessing treatment, disability, and impairment, and monitoring and updating the plan. As other dynamics come to light, further investigating, documenting, and updating of the plan should follow. This is all an ongoing process up until the claim has reached the conclusion stage. As discussed in my last video lecture, the final stage of the claim process is to conclude the claim. In the simplest terms, you are going to be reacting to your determination to whether the harmed party is due compensation under the terms of the insurance policy. If not, you will typically draft a denial letter to that party, as well as call them to discuss your decision. If so, hopefully you'll be able to work with that party to pay their damages in a pre-suit settlement. This usually involves the harmed party signing a settlement release agreement, agreeing to the terms of the settlement, and then you making payment to them directly. If a resolution cannot be reached with the harmed party, it is possible that they may pursue litigation in the matter, and a judge or jury will eventually dictate how you will make resolution. Thank you so much for joining me today, and I wish each and every one of you great success and joy as your learning journey continues.